Hello everyone, it's Chris Clark with discgolf.law. Macie Veladiaz recently announced that she is leaving Dynamic Disc after 3 years, and there's been a bit of controversy around her departure. According to Macie's Facebook post, she had decided to stick with Dynamic Disc as her sponsor for 2024, and when they went to discuss terms, Dynamic Disc presented Macie with a contract offer that was lower than she expected. Shortly after that happened, Macie informed Dynamic Disc that she is pregnant. After discussions with her doctors, she had decided to play 10 tournaments in the 2024 season. Upon receiving this news, Dynamic Disc presented Macie with an updated offer that was lower than its previous offer. Macie ultimately decided not to re-sign with Dynamic Disc and seek sponsorship opportunities elsewhere. We decided we wanted to talk about this because we got several questions asking us whether it is legal for Dynamic Disc to do this. Does Dynamic Disc making a lower offer to Macie based on her pregnancy amount to unlawful discrimination? One important factor to consider in analyzing this question is Macie's status with Dynamic Disc, and here's what I mean by status. Is Macie considered a Dynamic Disc employee, or is she an independent contractor? I think most people, including Dynamic Disc and Macie and myself, would say that she is most likely a contractor and not an employee. To be honest, I probably don't have enough detailed information to give a firm opinion one way or the other, but here are some reasons why I think this is an interesting and somewhat nuanced issue. Employees in the United States are protected from discrimination based on the Pregnancy Discrimination Act, which provides that discrimination on the basis of pregnancy, childbirth, or related medical conditions is a type of unlawful sex discrimination. To win a pregnancy discrimination case, you must show that you were treated differently than other employees who are similarly situated. The difference in treatment was based on your pregnancy. So if Macie were considered to be a Dynamic Disc employee, this could be an issue. I can hear most of you now saying, but she's not an employee, she's a contractor. And again, that is probably correct, but the determination is not as simple as you may think. There are several factors that determine whether someone is considered an employee or an independent contractor. It may surprise you to learn that the company wanting the individual to be a contractor and the individual wanting to be a contractor and having a written contract between the two that states that the individual is an independent contractor and not an employee has almost no bearing on the legal determination here. Well, the IRS has published a lot of helpful guidance on this topic, one of which lists 20 different factors that are to be considered in correctly classifying whether a worker is an employee or a contractor. I'm not going to go through all 20 here, but I did want to point out a few of them that I think are relevant in Macie's situation. One factor is whether the individual is permitted to do work for multiple companies. It's not unusual for contractors to provide the same services to multiple different companies, which is typically not the case for an employee. Disc golf player contracts are typically exclusive, meaning players cannot sign with multiple disc manufacturers at the same time. On the other hand, players routinely seek other types of sponsors, and some players even provide disc golf related services, such as providing commentary for companies other than their main disc manufacturer sponsor. A second factor is whether the individual is permitted to delegate all or a portion of their work to someone else. Companies that insist on a particular person performing the work assert a certain degree of control that would suggest an employment relationship. To contrast that with contractors are typically free to assign work to another person or other people. In the case of professional disc golfers, obviously the individual who is under contract is required to perform all of the services themselves. Another factor that we look at is who provides the tools and equipment that the worker uses. Workers who perform most of their work using company-provided equipment are more likely to be considered employees. Work that is largely done using independently owned or obtained supplies supports a conclusion that that is an independent contractor. In disc golf, obviously a player typically is only permitted to throw discs from their sponsor. In other words, only able to do their work using company-provided equipment. Now, some other factors include the extent to which the company directs when and where and how the work is done, whether there is training provided by the company, and the flexibility of the worker's schedule. Now, I'm not suggesting that Macie should be considered a Dynamic Disc employee, but I think it's not as clear-cut a question as some might think. Balancing the various factors that we've discussed, I still think it would slightly lean in favor of her legally being considered an independent contractor. But I think it's an interesting question, especially since it's likely one that players in the FPO division will face in the future from time to time. Curious to hear your ideas. What provisions could be used to address pregnancy in player contracts? Is this simply a case of a player playing fewer tournaments and therefore being entitled to lower compensation? Or is it more complicated than that? Should provisions be put in contracts to accommodate absences for pregnancy and other issues that might temporarily interrupt an FPO player's career? Curious to hear your thoughts. Please like, comment, subscribe, and as always, thanks for watching.